City of Shreveport. We'll hear first from Mr. Stevens.
May it please the court, I'm having a little bit trouble with my hearing aid here. I had to take my real hearing aids out to be able to use this one, and it's popping on me, so I may misunderstand some of the things you're saying. My name is Jim Stevens. I was also one of the trial attorneys in this case as well as appellate. This case, on the basis of qualified immunity, has been before this court through a different panel once before. And, excuse me, I've dropped. Well, I'll do it from memory. I just found it. This case before this court once before, a separate panel. The district, on the basis of qualified immunity, the district court had denied qualified immunity to defendants based on disputed issues of material fact. If resolved in favor of plaintiff, demonstrate that Corporal Pacino, one of the defendants in this case, violated Poole, who was a plaintiff at that time, clearly established right to be free from unreasonable seizure. A panel of this court, in upholding the district court denial of qualified immunity, reiterated those disputed facts, stating, if a jury views the disputed facts in favor of the plaintiff, concluding that Corporal Pacino shot Poole without warning, seeing that he was empty-handed, and turning away from the officer, then Pacino violated Poole's clearly established right to be free from unreasonable seizure. After close of evidence, following a 30-minute recess for deliberation, and after stating its factual findings, the court addressed plaintiff's counsel saying, you, of course, are not going to argue with me on my factual findings. Those factual findings, which defendants described in their brief as having been made in haste and prior to any conscious thought, were, by preponderance of the evidence, it was persuaded that Corporal Pacino had convinced himself that his life was in danger before he ever got out of the car. Number two, there was never an aggressive move by Poole, that Poole's back was to Pacino the whole time, and he did not believe Pacino's hip movement story. Number three, that Pacino was not given time to comply with any order, whether required or not, that might have been given by Pacino. Four, that Poole could see Poole's hands with his right hand on the rail of the truck and his left hand opening the door of the truck. The court concluded that Pacino's use of deadly force was objectively unreasonable and excessive. The next morning, the district court, following closing argument, and without any change in its factual findings, held that Pacino was reasonable in shooting Poole because he thought Poole was trying to get back into the truck, cab of the truck, to get a weapon. This, even though disputed facts were found in Poole's favor. 1 week later, the judge had said he was going to issue a written ruling, more formal. 1 week later, the district court changed its conclusion in the verbal ruling that Poole was, meaning that Poole was trying to get back into the cab of the truck to get a weapon, to it was reasonable for Pacino to believe that Poole had retrieved a weapon from the bed of the truck. What had happened, Poole had stopped, jumped out of the truck, reached into the bed of the truck, comes back out from the bed with nothing in his hand. Then, I'm sorry, I don't.
What was he looking for in the bed of the truck? What was he reaching in there?
I'm sorry, ma'am, I can't hear a word you're saying. If you speak to the mic, I maybe can.
What was he looking for in the bed of the truck?
Well, it turns out he was looking for a cold drink to take a bottle of pills and commit suicide. That's what his deposition revealed Now, the thought was that Brasino was thinking he was seeking a weapon in the open bed of the truck, as illogical as that may be.
Well, wait a minute now. The district court grappled with that. I mean, the district court credited that we now know, or the district court now knows, he was reaching into the truck or the back of the truck for a drink. The district court grappled with various things, including the video, because if you slow it down, and I've watched it as well, maybe not as many times as the district court did, but if you go frame by frame, et cetera, it's clear that he doesn't have anything in his either hand. But Brasino said, I didn't see his hand. I couldn't see his left hand. And the court credited Brasino's testimony as a fact finding, right? I mean, I'm looking at the memorandum, I guess, that was reduced to writing after the trial.
Yes, he did. In his,
But isn't that what we go by, is the court's written memorandum explaining its decision?
It is. And for the moment, let me say that his left hand, at first, the judge, at the close of evidence, stated that he could see his hands, and he believed he could see his hands. And his next morning, in his verbal ruling, he said that he didn't change anything. He just said he thought he was trying to get back in the cab of the truck to get a weapon. Then, in his...
Are you talking about the district court's interpretation of the video?
This district court's interpretation of the video and his verbal ruling.
But that's distinct from what the officer said or testified to seeing or believing at the time.
Well, he testified that he could see his hands when he got out of the truck and they were empty.
The officer did?
Yes, the officer did, yes, multiple times. And matter of fact, their excessive force expert testified that the officer could see his hands when he got out of the truck and they were both empty.
He got out of the truck, but after his one hand goes in the truck bed. Of course, the other thing is all this happens in about 4 seconds, right?
Well, it was a total of 8 seconds. And the part where after he jumped out of the truck is about 6 seconds for the rest of it to occur. The time that from Brasino jumping out of his vehicle and clearing the door and starting to shoot was 1.133 seconds. And it was a very short period of time.
Very short period of time, but it follows a pretty protracted slow-speed chase through various neighborhoods in Shreveport, right?
Right, about 15 minutes at they said the 15 to 20 mile an hour average speed limit. And they through a lot of neighborhoods in Shreveport. It was over 15 minutes. But Brasino testified that he could see him reaching. He said it at the scene. You can be overheard telling Sergeant Kane, who had taken over charge of the scene, that he thought he was reaching into a bag and he thought he was trying to get back in the cab of the truck to get a gun. He said it 4 days later in his official statement to Sergeant Ivey that he was reaching into a bag with his right hand and he thought it came out with nothing. He thought he was trying to get back in the cab of the truck to get a gun, which is consistent with the showing of the film that's used as a training film of the officer Nichole in Georgia. Y'all probably seen that. It was a brutal murder. The officer pulls the guy over. The guy gets out of the truck, starts dancing in the street, runs around the truck, does all kind of stuff, charges the officer twice, says, shoot me. The officer didn't shoot him. He goes back to his truck, gets a rifle out of the back of the truck, and holds it. The officer shoots, then he shoots the officer. Then he runs over there and shoots him again, and it's a brutal murder. They showed that film, but the film is geared to a perpetrator getting back into the cab of his truck and get a weapon. And that's what initially Brasino said in 2 instances. And he said it wasn't that he thought he retrieved a gun from the bed of the truck until his deposition was taken 2 years later. And so I think it's clear that everybody thought that he was trying to get a gun from the cab of the truck. It wasn't until later, and plus it's illogical. No one carries a gun in an open bed of a truck. And he could see him. He said he reached in with his right hand. He brought his right hand out. He admitted on the stand that it was empty. He put it on the rail. He admitted that it was empty. He admitted that he said the whole thing was the turning to shoot him. And that's what his expert said. His expert said, when asked by the court, what was the thing that made him feel like his life was in danger at the moment he's standing out there with his gun on him? He said the turning, but you can view the film 100 times, you'll never see him turn. He turned his head as he had his right hand on the rail, his left hand on the door. He turned his head, and then he comes back, he opens the door, he has it halfway open. And his right hand's still on the rail when the first shot is fired. When the second shot is fired, he's got his hand, the door is widely open, he's going in with his right hand, and the second shot is fired. The third, fourth, fifth, and sixth shots, he was partially in the truck every time he was shot. I don't know which ones, he missed him twice, and we don't know which ones those were. The use of force expert, Mr. Nichole, testified to the question by the court. He said, the statement given to Sergeant Ivey that he thought he was trying to get back in the cab of the truck to get a weapon indicates that he knew he did not have a weapon at that time. He also said, if you look only at the dash cam, deadly force was not justified. And he said, and again, I pointed out the justification that the use of force their experts said, was the turning of his body or turning of his hip. And the judge called it a hip movement story, and the judge didn't buy it. He never changed his position on that. The question was whether it's consistent rulings. First ruling is, he didn't believe any of it, and it was objectively unreasonable. The second, that was at the close of evidence, but he said, I'll give you a chance to talk me out of it. And defendants talked about instant replays and the amount of calls, referee calls that are overturned by instant replays, like I think they said 40% of them. But, so whatever the officer sees is not necessarily what you can see, and that's true. But in this particular case, he admits seeing that right hand. The right hand is the only hand in which a weapon could be had. He admits that's the hand he was reaching into the back of the truck. He admits it came out empty. He admits it was on the railing of the truck. The left hand, whether he could see it or not, doesn't make any difference. He could see it when he got out of the truck and it was empty, and he admitted that.
But we've got findings of fact
Right.
by the trier of fact, which in this case was the district court. I mean, we've got to go by the clear error standard of review, do we not? In other words, unless the court was clearly erroneous in finding the way the court did, we affirm, right?
Well, we don't question the trial court's findings of fact. We accept the trial court's findings of fact. He changed. The only fact that was changed from the statement of what he said at the end of the close of evidence, the only thing that was changed was he said he couldn't see his left hand. But the left hand doesn't matter. He could see it, and he admitted seeing it and the judge knows this, when he got out of the truck initially. But the right hand is the hand he did all the reaching. If he was retrieving it from the bed of the truck, the right hand is the only one. The first verbal ruling was that he was trying to get back in the cab of the truck to get a weapon. And that changed in a week. We don't know nothing changed other than the fact he changed. The only factual finding that changed was that he couldn't see his left hand. His initial ruling was he could see his left hand. And in his verbal and at the ruling at the close of evidence.
If we uphold the district court's finding that Officer Brasino couldn't see the left hand, can you still win?
Could we still win?
Yes.
I think so, yes, sir. Because the left hand doesn't matter. District court knows that he could see his left hand. It was empty starting out. The only question was, the district court said he retrieved it's reasonable to believe he retrieved a gun from the bed of the truck. The only hand with which he could have done that was the right hand.
Thank you, counsel. You've reserved time for rebuttal.
Thank you, sir.
Ms. Buckle.
May it please the court, like Mr. Stevens, I also was trial counsel and was here before this court, before a different panel. In that case, the panel did affirm the district court's denial of summary judgment on the basis that there were genuine issues of material fact. And the primary issue at the time was whether the fact finder could determine that Corporal Bursino saw that Poole's hands were clearly empty at the time he fired. This case proceeded to trial, and the fact finding was that Corporal Bursino did not know that his hands were empty at the time he chose to fire his weapon. And so that is a fact finding that was made by the district court, and Your Honor's correct, it is a clearly erroneous standard.
But what about the inconsistency between what the district court said at the close of evidence versus what shows up in the memorandum explaining the ruling?
Correct. Well, I think at the close of evidence, the judge was very clear that it was a preliminary statement. He never said those were his factual findings. He came in and he said, let me tell you where I'm at right now. You can come back tomorrow and give me a chance. And he told us, I'll give you a chance to tell me why I'm right or wrong. I mean, it was very clearly a preliminary statement that he was not, and it was not intended to be a finding of fact at that moment. So, I mean, I do recognize that the next morning, his finding was different than his preliminary statement, but I think that occurs. I mean, if this was a jury, they would have retired to deliberate, and jurors often change their minds during deliberations. So I don't believe the preliminary statement is inconsistent. I think after he had the opportunity to go back and review all the evidence, his fact finding is that Corporal Bursino did not see that his hands were empty. So this court has to take that factual finding and view all reasonable inferences in favor of Corporal Bursino in this case. I think what's important is the timing. I mean, we have 8 seconds total from the first moment Poole brought his vehicle to a stop, and it's less than 4 seconds from when Corporal Bursino begins exiting his vehicle. In that time, he had to respond pursuant to his training in what he believed was an ambush situation. He had to get out of his vehicle, out of the fatal funnel that it's called. He had to move to his left. He had to draw his weapon. Sirens are going. He's giving a command for Mr. Poole to put his hands up, and he's having to assess the threat in milliseconds. This is how quickly this was unfolding. He's having to make this threat assessment. And he testified consistently throughout the litigation, especially at trial, that he did not know Mr. Poole's hands were empty, and when he saw the movement, he believed Poole was turning to fire at him. And so in that moment, he believed it was a lethal threat, and he responded the only way that was proper based on his training, and that was to respond to a deadly threat with lethal force. We know based on the video that his hands were empty. That was not the perspective that Corporal Bursino had. I think Mr. Fredericks, one of the experts that testified, said one of the most dangerous concepts you can have is to believe that the video is a silent witness, that the video speaks for itself, because especially in this case, Corporal Bursino did not have the same perspective as the video. So while it certainly can provide information, we cannot use that to change the perception of Corporal Bursino and what he saw. I think Judge Walter, the district court, he had the opportunity to listen to all the testimony and make credibility determinations, and that's ultimately what this case hinges on, is whether he believed Corporal Bursino, and it's obvious based on his facts finding that he did. Even if this court were to disagree with the district court on whether Corporal Brasino's actions were objectively reasonable, which the district court found, there's still a second prong that has to be addressed, and that's whether Corporal Brasino's actions were objectively reasonable in light of clearly established law. And that is not an element that the plaintiff's counsel has argued at length. I believe this court and certainly the Supreme Court in recent years has been very clear that there must be jurisprudence that squarely governs the fact of the case, and it must be beyond debate to show that the actions of the officer were unreasonable.
Well, this court sort of answered that, though, in the prior panel opinion, did it not? I mean, in other words, the whole thing hinged on these disputes of fact.
Correct.
I mean, there was really no question about prong two.
I would agree. The whole case hinges on whether Corporal Brasino saw that his hands were empty.
What about counsel's argument that the left hand didn't matter? The right hand was the one reaching into the truck and groping around for whatever it was, and then he says he can see the right hand is empty, but the left hand, I'm just not sure about the left hand, but I mean, you could see in the video when he gets out of the truck that both hands are empty, correct?
You can see from the video, but that's not what Corporal Brasino saw. Corporal Brasino had exited his vehicle, was moving to the left, and Mr. Poole had his back to Corporal Brasino. So I would disagree that the left hand is irrelevant because Corporal Brasino doesn't know that Poole hasn't pulled a weapon out. He doesn't know that there's not a weapon in his left hand. All he knows is that Mr. Poole has moved away from the bed of the truck towards the cab and then stops and begins turning back towards him. And so, and again, this is happening, he has milliseconds to assess the threat. This goes back to the qualified immunity. Perhaps it was a mistaken judgment, but it was a reasonable judgment. And the district court in its oral ruling said, it's all well and good for me with the leisure of seeing the event 15 or so times to say what I did yesterday, but that isn't what happened or when it happened or where it happened. And I think that's true. And I did count during in reviewing the transcript, it was a minimum of 15 times that the district court viewed the video throughout the 2 days of testimony. This court's now reviewing it for the second time on appeal. And we had an expert testify that it took him 3 hours and 45 minutes to analyze 8 seconds of video. This is the exact type of case that qualified immunity is designed to protect. Corporal Brasino had to make an assessment, and he acted in accordance with his training, just as the district court determined. So we do believe that the findings of the district court were correct, and that that the ruling should be affirmed. I'm open to any questions that the panel may have.
I think we've got your argument. Thank you, counsel.
Thank you.
Mr. Stevens, you've got 5 minutes.
I'm sorry?
You have 5 minutes.
Yes. If I may please the court, this is going to be brief. Brasino has told 3 stories. The first story was he thought at the scene and to Sergeant Ivey in his official statement to the police that he thought he was trying to get back into the cab of the truck to get a weapon. He told that same story, well, twice within 4 days. 2 years later, he said he was trying to get it. They thought he had gotten a gun out of the bed of the truck, which he maintained at trial. The third story occurred in his qualified immunity motion for summary judgment, that he thought Brasino was trying to get back in the cab of the truck to continue his flight and endanger lives. So his credibility is, I think, questionable. The Corporal Brasino, the story came out that he said he couldn't see his hands. That's not true. He said he could see them when he got out of the truck and they were both empty. He said he could see him reaching in the back of the truck with his right hand, and he saw him withdrawing and it was empty, and he saw him put the empty right hand on the bridle of the truck. He could see the right hand. Granted, he says he couldn't see the left hand, but he did say on cross-examination that he had a better view of the left hand than the dash cam did. And he certainly had a good view of the left hand when it was outstretched, holding the door open when he fired the second, fourth, fifth, sixth, and fourth and fifth and sixth shots. So he could see, but the right hand he could see the whole time. He never denied that. As far as his testimony, the hands being empty, that's not true. He testified that they were empty when he got out of the truck, and as I mentioned earlier. The warning, the judge dismissed the warning. He said if he gave one, it was indecipherable. And if you listen to the tape, the warning and the first shot occurred about the same moment. As far as he stated his factual findings, he told plaintiff's counsel that you will not argue with my factual findings. The next morning, and he said what he planned to hold was in our favor. The next morning, he didn't change any factual findings. He just said he thought he was trying to get back in, the reasonable think he was trying to get back in the cab of the truck to get a weapon. So the first two factual findings, finally, the only factual finding was that he couldn't see his left hand, whereas initially the judge said he thought he could see, in his opinion, he could see his left hand. That changed. Well, we can accept that, but with the left hand is immaterial. Thank you.
Thank you, counsel. The case is submitted. We'll take a brief